case. They want Wade off the case. They want her team off the case, her whole team off the case. They wanted all 41 charges to disappear. Of course, not all those charges are Trump's, but essentially, that's what that camp wanted. And obviously, Miss Wade wanted to continue to stay on the case and prosecute, to the whole thing, right, in its entirety.
The defense in this motion, remember, it was a disqualification, but it goes hand in hand with the defense's overall effort to have this case fully and completely dismissed. The defense in different portions of it have long maintained that this is a purely political prosecution, that shouldn't have happened, that if there were any issues, they should have been handled in federal court. There was a lot of argument, in fact, some of it's still ongoing, about moving the case to federal court, which does not appear to be happening. And the defense has raised these new and novel issues, trying to create a situation where Judge McAfee doesn't have any choice but to take aggressive actions against Fani Willis's office. Now, what the ruling really represents is that Judge McAfee has heard all of the defense's novel and unique arguments, has really heard them and comprehended them, and in order to regain the legitimacy of the trial, in order to save the integrity of the criminal justice process, he put the decision back on Fani Willis, and that's a key pivot point. What Judge McAfee did is basically say, Miss Willis, it was your choices that brought this issue to a head. It's your choices that the defense investigated, discovered, and then brought to the court's attention. And the judge is pretty clear in looking down on D.A. Willis for the choices that she has made. There are several instances in the ruling that can be considered colloquially as bench slaps, which is where the court is telling the litigants, don't do that again. That's a bad look. That's a bad decision. And now he has put the decision of how to proceed back on Fani Willis because she is the elected DA. There wasn't a requirement that she be disqualified. However, due to the appearance of impropriety, a remedy was necessary. The creative remedy used by Judge McAfee is to force D.A. Willis to either dismiss her whole office or dismiss her ex-boyfriend, Nathan Wade. Right.
And like you said, I mean, Judge McAfee has essentially put the onus back on Miss Willis to make that choice. If you want to keep this case, you want to stay on this case, you got to get rid of him. So what is that? I guess what does the path forward look like at this point? Because we've talked a little bit about the possibility for appeals. You've explained that any of the defendants can appeal. The prosecutors can also appeal this decision. So I guess in this case, you say that there is a required application to even go forth with an appeal.
Yeah. So let's look at what's going to happen immediately. Everybody's going to go home and yell and scream at everybody they're talking about the little bit that they won and the lot that they lost in getting this ruling. But the big decision, the first decision, Fani Willis needs to decide what's going to happen with Nathan Wade, but at the same time, she has to consider whether she wants to appeal this ruling in the first place. And those decisions are independent from each other. She can make a decision on Nathan Wade while considering whether to appeal or not and comply with the requirements of the order while also pursuing appellate remedies. The issue with the appeals is this order did not, and the ruling did not come with an automatic certificate of review like the order did that we received on Wednesday regarding the dismissal under the demurrer of those 6 solicitation charges. Today's ruling didn't include that, so if any litigant who adopted this motion, and that's not all Trump co-defendants, I believe it's about 6 or 7 or 8 of them, those litigants, they can apply within 10 days for a certificate of immediate review. The decision whether to grant that certificate of immediate review is discretionary by Judge McAfee, and at that point he will decide whether this has a fast track to the Court of Appeals or whether they've got to go through the regular normal appellate process that takes far longer than the accelerated one available through a certificate of immediate review.
So, talking about the timeline, I mean, this thing has now been greatly delayed. I mean, this is already just the disqualification hearings were a delay in themselves, but what do you think is a possible date that we could actually see a trial?
Well, we could possibly still see one prior to November, and a lot of people are talking about trying to get this tried in August or September, which would be the first available realistic opportunity, but that window is closing very rapidly, and it actually accelerated that closing with today's ruling, because both the state and the defense can apply for the certificate of immediate review. That's on top of the appeals options they have from Wednesday and the other rulings in this case. So there will be some appellate action coming. How that impacts the trial date, well, these issues are fundamental to the case. So I don't believe Fani Willis is going to achieve her goal of trying this case prior to the national general election in November, but it's still an option.
Okay, so you don't think it will happen before November. When do you think?
You know,
You're such a lawyer, Josh. Just give me a straight answer.
I'd love to be like, man. So if Fani really wants to push this hard and put this up on trial before November, there's no appeals coming from her. She's got to pedal to the metal this.
Yeah.
She has to appoint the replacement prosecutor or substitute in and identify the lead prosecutor that's already going to be in this office and get rid of any potential barriers to the state being ready to move forward.
It's not going to happen before November.
The state has to be ready. Then you get to the defense's arguments as to why they can't be ready or aren't ready.
Okay.
Like we're seeing in the Aileen Cannon case in Florida and the Southern District of New York case. Late appearing evidence, impacts from other courts can delay a court trial immensely, months and months and months.
All right, Josh. So let's talk about the different options that we could see, because now we've got a little bit of the timeline. We know that any of the defendants could file an appeal. We know that the prosecutor's office could file an appeal. In theory, you say that realistically that's not going to happen because they don't want to slow things down. You don't think it's possible that maybe Fani Willis says, okay, Mr. Wade I'm going to comply with the court order. I'm going to remove Mr. Wade from the prosecution here, but I also want to file an appeal so that maybe I can bring him back on the case. You don't think that's possible?
It's possible, but I don't believe the tie to Nathan Wade remains as strong as that. I know there's personal feelings, but then there's professional obligations as well. And if Fani Willis files an appeal, it could be interpreted, and I will interpret it, as basically saying we're giving up on trying this case prior to November.
Okay, but here's the other question. Okay, sorry, Josh, go ahead.
Oh, no, I think she's been around a long time. She's a very sophisticated litigator. She understands the game being played, and any hiccup drives that trial date back.
What about this possibility? What if Miss Willis actually says, hey, I want to get off this case. You can have Mr. Wade on this case. I want to get off. Do you think that's something we could even see?
Well, remember, if Fani Willis leaves the case, it's her entire office, which would include Nathan Wade anyway.
Okay.
What the real undertow is, Nathan Wade's off this case. It's whether Fani Willis wants to retain a Fulton County DA's office role in this case, or if she's going to pass this case on to Pete Scandalakis of the Prosecuting Attorney's Council of Georgia for him to assign a DA.
Okay, so in terms of appeals from, Mr. Sadow, who is Mr. Trump's Georgia attorney, and the other defendants, are we going to see, I would anticipate for Mr. Sadow, we're going to see an appeal saying, hey, we want all the charges dropped, and we want all of these prosecutors off the case, Willis, Wade, everybody off the case. Is that reasonable?
That's an absolutely fair conclusion. I don't think it's going to come today or tomorrow, but probably towards the end of that 10 days, we're going to see a very thorough application. It's not that long. But Steve Sadow, as he brought out, has a lot of issues and problems with the way McAfee ruled, specifically indicating and talking about Miss Willis's speech at the predominantly African-American church, which many argue was racially polarized. There are other issues that Steve Sadow wishes the court had taken into consideration that would have disqualified Miss Willis more aggressively had they been considered and ruled as valid by the court. Since Judge McAfee has chosen not to really go through those issues to the degree that Mr. Sadow wanted, Mr. Sadow has a legitimate appellate issue trying to force the court to consider that evidence.
When we talked about the 6 charges that were dropped earlier this week out of the 41, so there are 35 remaining, and we've been talking about it, Josh, offline, that this was sort of a foreshadowing.
Are you saying we gossip and chat a lot?
Yeah, and only about legal cases, right?
Yes, yeah. Hey, This stuff is that interesting, so don't beat yourself up. This is the most fascinating, emotional story combining politics, entertainment, culture I could possibly.
Well, our YouTube comments are like, I can't even keep up. There's so many people. We got somebody watching from Canada, in fact.
Yeah, I have been reached out to. I've never had an issue, rather, that I've had as many people from so many different places reach out about. This morning I was talking about this case immediately after the ruling dropped with people in Canada and people in Dubai. This is where the entire world is looking right now.
There's someone saying, vote McAfee out of office. Someone else says, bravo to the judge. I mean, the opinions are all over. I mean, you've got someone writing, lock Fani up. Others are saying this is, a racist witch hunt. So you got opinions on all sides.
Yeah, and that's one of the really fascinating parts about this is there's a lot of very legitimate criticisms, no matter where you find yourself on a political or crime and justice spectrum. There are really legitimate complaints anytime a prosecutor, who is the highest representative of the state in a criminal justice process, does something that's unethical, potentially illegal, or presents an image that detracts from the integrity of the criminal justice process, because all citizens deserve a criminal justice process that is filled with integrity, overflowing with integrity. That's why these appearance of impropriety or actual conflict issues have been so thoroughly litigated over decades and decades. If you read the order, there's a ton of cases that Judge McAfee relied on to guide him in making the decision today. Those cases told him what he can consider, what he doesn't have to consider, the standards that were at his available use, as well as the remedies that he could craft on his own, which resulted in this very creative but I believe correct option where D.A. Willis has to decide herself, since she's the elected leader, how this case is going to move forward.
Yeah. So like you said, I mean, a lot of it now has kind of been pushed back to Ms. Willis for her to decide if she wants to stay on.
Let me add one other thing that could happen.
Okay.
Nathan Wade could stand up and leave this case under his own volition. He is technically an employee of the DA's office. He's been specially appointed, but that's his boss. He could submit a resignation outside of Miss Willis, even if Miss Willis wanted to keep him on. Now, that's going to be a personal decision, and I'm not privy to where Nathan's brain is right now on such a difficult decision. But
Well, what would be the point
that's
of
the high
that?
road for him.
Well, what would be the point of that if he knows that likely Miss Willis is going to remove him from the case? Why would he submit a resignation?
Well, if he's trying to
Save face?
yeah, make a gift for Miss Willis. There's a very strong argument.
I feel the jokes coming. I feel
Yeah,
the jokes coming on YouTube from what you just said.
It really is. So, what's fascinating is Nathan Wade could have seen this coming several months ago and just stepped aside then. I think that would have kneecapped a lot of President Trump's arguments and the other co-defendants' arguments and reduced the political pressure that we're all seeing. If he had just stepped aside and said, hey, there's going to be some issues that I'm ethically secure in, but are going to be a distraction, I, Nathan Wade, am going to take the high road and step away in the best interest of justice, we wouldn't be here today. We'd be arguing over other stuff, and that November or that prior to November trial date would be much more realistic. Instead, we've now had 60 days of high drama where the health and integrity of this prosecution is now rightfully questioned by people of all stripes. This isn't what justice is supposed to look like, and Judge McAfee was very clear with that, with those bench slaps in the ruling.
So, just because I want to bring us back to our viewers a little bit, and I have to say, some of our viewers, have really, have clearly read up on the case and have very insightful comments. Some people just have some very off-the-wall comments. Sorry, no offense. You know who you are. Probably doing it to get attention. But some people are saying, really that there should be repercussions for Fani. And it looks like apart from all this, I mean, more repercussions for Fani, Miss Willis, but it looks like apart from all of this, there absolutely are, because, you know, there's the threat that she could be held in contempt for a failure to comply with a subpoena from
Jim Jordan.
Right,
Yep.
that's right. And of course, there are other ethics investigations here in the state of Georgia as well. So what kind of sanctions could we see for Miss Willis apart from what we're seeing here?
It's going to depend on what forum those sanctions are being considered. From the very highest of the high, Jim Jordan's a sitting Congress member. If you are in direct contravention or in contempt of a United States House of Representatives subpoena, you can be sent to prison. We actually have had a couple trials on that exact issue and a lot of litigation over the last several years. I don't think that's nearly as likely as some more local remedies. Fani Willis is going to receive people or complaints to the Georgia Bar, to the State Board of Ethics involving her behavior. Judge McAfee actually, in the opinion, references how his court is not the appropriate forum for some of those remedies, but those remedies are out there, and it'll just be a matter of time to see how those manifest. Remember, to many people, Miss Willis and Mr. Wade have lied and possibly committed perjury, which is a prosecutable offense. You go to prison for that in Georgia, and there's going to be a call amongst many people in the community for them to be prosecuted.
Yes, and there is. I mean, I see people right here on our YouTube channel saying exactly that. I see one person who calls themselves Fred Flintstone saying jail Fani for malicious prosecution. I mean, that's not realistic, though, is it?
Malicious prosecution wouldn't be the appropriate angle, but it's more about what choices and behavior she has made and performed during this prosecution that are subject to judicial restraint, ethical restraint, or other professional obligations. Going out to the AME church, many people are going to really harp on the fact that that was wholly and completely inappropriate, even though she did, as Judge McAfee notes in the ruling, not mention President Trump by name. But it was clear what she was talking about, and it was a very racially polarized speech. That going out into the public and discussing an active trial litigation issue, that's frowned upon, if not prohibited, by the ethical canons. As an elected district attorney, Fani Willis doesn't just have to comply with the standard Georgia bar ethics required of all lawyers, but she has an additional set of ethical duties as an elected official and top constitutional officer. She has to be mindful of those, and she's presumed to know them all and be familiar with them as well as comply with them.
Right, and you know, that's something that actually Mr. Sadow referenced in his response to this decision. Mr. Sadow being Trump's Georgia attorney, you know, referenced that appearance at Big Bethel AME Church and actually accused Fani of you know, playing the race card, Miss Willis of playing the race card. And, you know, it sounds like just that practice of kind of talking about this case in an extrajudicial setting as a prosecutor is problematic. What kind of repercussions could there be?
Well, there can be ethical repercussions from the bar. There can be appellate repercussions when it comes to the actual case and the result of the case. If there is a conviction, there is an appellate route to claim that the prosecution was unfair due to basically poisoning the jury pool about the case prior to it being tried. Since the state has such a dominant amount of information that's protected and privileged, they have a forum and an opportunity and a soapbox to get out and talk about cases before due process has really started. That's fundamentally unfair. It is prohibited for prosecutors to do that. But we still have this AME speech, and that is an open source for attack against Fani Willis. There's also the Georgia Board of Ethics, which that's going to get into the propriety of constitutional officers hiring and firing people that they have a more or less than arm's length relationship with. And as we've discussed extensively, allegations that Miss Willis and Mr. Wade began an intimate physical relationship as far back as 2019 have been widely alleged. If that's true, it contradicts the testimony they gave in open court. Many triers of fact would look with a skeptical and aggressive eye at that kind of situation.
And ultimately, you know, it sounds from the language of Mr. McAfee's decision that it is the appearance of impropriety that really was the issue here.
Yes, he does an extensive discussion about what standards apply and the whole improperness discussion as a whole. An actual conflict is different from the mere appearance of impropriety. An actual conflict, if one had been proven and corroborated and not contradicted in the evidence, an actual conflict would have required Judge McAfee, required him to disqualify Fani Willis. And he ruled that he had not received that appropriate level of evidence or threshold of evidence in order to require a disqualification of Miss Willis, something that Miss Willis has been emphatic on the entire time, and she's been proven correct. There wasn't a required disqualification. As for the permissive or disqualification, that is what Judge McAfee felt there was enough evidence to support, primarily, we're going to assume, from the testimony that he watched. He gets to decide how the testimony provided in this case lands with him. The weight is what we call it in the law, whether it's truthful or less than truthful, whether you fully believe someone or whether you feel they weren't honest with the court. And I think it's clear Judge McAfee had some pretty big questions regarding the honesty of some of these answers. That's a bad look. The fact that those answers were coming from the state is an even worse look, and that justified his use of a remedy. I also want to note right here, this case has not experienced a gag order, and for the first time, Judge McAfee, in this opinion, references a gag order in some of the dicta where that may be forthcoming. A gag order, I believe, would prohibit the state specifically from making any extrajudicial statements, but obviously there are compliance issues with the former president. He has bumped heads with courts involving gag orders many times before.
Right, and he's been talking about this prosecution publicly. He's talked about Ms. Willis and Mr. Wade publicly, and this investigation that has resulted in this decision here today. I see here that some people are calling actually for Judge McAfee to be investigated. What do you think of that?
Extraordinarily unlikely. Judge McAfee's appointment was very clean. It was very reasonable. There were no objections to it. I know people question his age and experience as well as his professional background. Remember, he, in many ways, could be called, and I believe fairly, someone who was groomed for a judicial position by the right side of politics. He is a member of the standard clubs and organizations that right-leaning jurists are oftentimes associated with, but it's unquestionable that he's provided years and years of dedicated public service. So the appointment of him to this case and him possessing the position of Superior Court judge, there's no play that's going to go against that. As for his behavior with this case, he is not dumb. Judge McAfee knows that every single eye in law is looking at this case, and he also knows that in the future he has to deal with all the appeals, and if he's ever submitted for a federal job in his future, he's going to have to sit in front of a Senate committee and answer unfair, probing questions about his actions this week. And that's years and years from now, so he has a long-term arc view of the judicial system. I've seen nothing to justify any kind of action against Judge McAfee, and in fact commend him for writing such a clean, clear, unambiguous order. He's locked down all of the loose ends, and he's insisting that he's not going to be the issue that causes this trial to struggle.
Okay, so I have another question for you. Say this prosecution goes forward with, Miss Willis as at the helm, and it's successful, that she achieves convictions of all the defendants, just hypothetically speaking. Could we see down the line, maybe it's a couple years from now, that conviction is appealed because of what we're seeing right now?
Absolutely. So hypothetically speaking, should Mr. Wade step aside, Miss Willis and the DA's office of Fulton County continue and succeed in obtaining convictions either through or through the trial process, in the background, people are going to be thinking about the appeals that could be brought on behalf of these defendants, even though they aren't necessarily ripe or justiciable at that moment, and the appeals process takes a long time. So imagine this scenario: Donald Trump is convicted of RICO, which is what's going on here, and then is convicted and sentenced. There can be an appeal pending during all that time about Miss Willis and Mr. Wade's actions in the lead up to that conviction that could then invalidate that conviction, bring it back, require the court take additional actions, have additional hearings, or even retry the case. If there is a significant derivation from the appropriate rules, regulations, and laws, that's the remedy. Go back and try the case again or dismiss it permanently.
And I see different folks kind of chiming in on YouTube. Somebody writes drop Wade. Just to be clear, I think it's pretty certain that that is going to happen, that Mr. Wade is going to be dropped from the case, because that's the only way that Miss Willis could proceed with her prosecution. Is that fair?
Yeah, that's absolutely fair. I believe Mr. Mr. Wade's days are numbered on this case. My question being whether he's going to submit a resignation or whether it's going to be an announcement from DA Willis's office.
Josh, I know we talked about this a couple of minutes ago, but I just don't really see the value of resigning when it's inevitable he's going to be removed. If he were going to resign, maybe it should have happened before all of this.
I absolutely agree. Had I been advising the people involved in this, I probably would have advised them to eat the bad facts up front, and it's easier to ask for forgiveness rather than permission. At this point, Fani Willis has to really size up the entirety of this case and look at its overall health and integrity. So what's better for her office's goals? Is it her firing a specially appointed prosecutor, or is it that prosecutor taking the burden upon himself as an independent lawyer? Mr. Wade has been around a long time. He's going to have a long career after this, and it may be better for the inertia and the optics of the state's case for Mr. Wade to acknowledge and admit the judge's ruling, accept it, and then move the case forward himself by resigning.
Right. Okay, that makes sense. Just kind of expedite things and kind of change the dynamic so that Miss Willis doesn't, become kind of the scapegoat in a way. Is that what you're thinking?
Yeah, and not to be too much of a conspiracy theorist, but hold on, I'm a lawyer. Nathan Wade is about to get kicked off the biggest case of his career. And it is clear that happened because of relations between him and the woman that appointed him and paid him. And his leaving that case, not necessarily of his own choice. Right. And there is the potential of a lawsuit, believe it or not, by Mr. Wade against Fulton County for the experiences that he had during the hiring. I don't know how many people know about this, but immediately, 4-6 weeks ago, there was a similar employer-employee case involving a Fulton County commissioner that started a consensual relationship that then ended, and the employee in that consensual relationship sued Fulton County and was awarded $900,000, which are taxpayer funds that are going to go pay this contractor because of the actions of a constitutional Fulton County officer. So I don't necessarily think Mr. Wade wants to go make a splash by suing Fani Willis, but it's technically possible.
Okay, so I see someone writing Willis is guilty. I mean, here's the thing. This is not a criminal trial. The guilty is not, that's not even.
She is not on trial. Now, did she do and say some things that are questionable, and could there be additional inquiry? And for all I know, if there's enough evidence, could she theoretically be brought up on charges for perjury? Sure, but that's not today. So today, she is not on trial.
And asking you about perjury, so I see some folks on here commenting, that she committed perjury. That's their opinion, that she committed perjury. Number one, is there evidence in your opinion that she did commit perjury? And number two, if so, what would kind of the recourse be?
It's not proven in my mind beyond a reasonable doubt, but there's certainly a colorable and justifiable allegation that she did lie to a court. I believe that the technicalities of perjury are going to get down to really difficult and granular semantics issues. What a relationship is versus not. Is a hookup a relationship? There's a lot of gritty, gray details in there that can be parsed about if there's an actual criminal action taken against Fani Willis for perjury, something that I don't think is necessarily likely to succeed, but it also doesn't mean that someone's not going to try to bring it. Georgia does allow people to apply for warrants against people. There could be complaints from other various groups. We'll have to see what law enforcement's response is if those allegations are made to the appropriate forums.
Josh, somebody goes, is this a faux Fox channel?
No! You gotta be kidding me. So I'll be
laughing.
blunt, and everybody keeps asking me what's my personal opinion of Fani Willis, and I'll be very clear. I supported Fani Willis when she ran against Paul Howard because Paul Howard was a terrible leader and a DA who really harmed the best interests of our community. So I wholeheartedly supported Fani Willis in her race and even worked with whistleblowers from Paul Howard's office in conjunction with that. I am a Fulton County resident, and I want a strong, efficient, well-operating district attorney's office. But what we have in this case is anything but that. Fani Willis allowing this issue to get to where we're at is a self-own, and it's not the best look for the law. And as someone who adores the law, I'm hurt because this process should have been bulletproof. What we all wanted was a clean, open, transparent, and effective prosecution, win or lose, of the former president. And he has some amazing lawyers. So we wanted a clean, good fight. That's not what we received, and it was because of the decisions made by Fani Willis and others prior to this case even coming about. I'll also comment on the politics of the lawyers involved and people accusing various defense attorneys specifically of being part of MAGA or a plant or a CIA. No, I've known these lawyers literally my entire professional life, and I can promise you thoroughly that the personal politics of people like Ashley Merchant, Scott Grubman, Manny Aurora, these defense attorneys, they are not reflected at all in their professional duties for their clients. And I think people would be surprised to see the real personal politics of these defense attorneys. It's a testament to their professionalism that they can set aside their personal politics and represent their clients so zealously, and they should be commended.
It's interesting. So someone here keeps writing, what about the judge and his wife donating to Fani's campaign? That sounds completely off the wall.
No, but it's not. I give money to lots of people that I appear in front of as well, and giving money to judges is something that's extraordinarily common in the legal community. It was a de minimis amount. And remember, Scott McAfee worked in the same office as Fani Willis. They were employees of Paul Howard together. It doesn't impute an automatic conflict just with some of these status acknowledgments. It is not an automatic conflict, believe it or not, to be married to another counsel. And as the judge indicates in the ruling, that's been thoroughly litigated in the courts of Georgia. To have an actual conflict, that is a very strict evidentiary standard. It's well defined, and Judge McAfee ruled that it wasn't present here with the evidence that he had. There could be additional evidence, and if there is, I'm certain lawyers will make sure we hear all about it. But for what the judge had in front of him, he didn't have that actual conflict. He did have the mere appearance, and that's the justification for putting the onus back on Fani Willis as to how this case is going to be prosecuted.
Yeah, no, it's very interesting. So some people are saying, why leave Willis on? Why is Wade basically being penalized, essentially? Like, why can't Willis get off the case and keep Wade on the case?
Well, Willis is the elected constitutional officer. She's the one that took the oath. The office and everybody in it replies and is responsible directly to her. She is where the buck stops, and that includes Nathan Wade. Nathan Wade was selected by her, paid by her, contracted by her. So it rolls uphill, you could say. Mr. Wade would not be allowed to independently operate as a prosecutor in this office without Fani Willis's express consent, permission, and request. That's just not how this works.
So we talked about the possibility for an appeal. You know, I mean, I'm just interested in how long-term this could impact the case, right? Because I wonder if this could come back to haunt the judge, essentially.
Aha.
You know what I mean?
That's a great.
There's
that's
a conviction,
great
then an
point.
appeal years later. You know.
So when a judge is considering a case, they also always understand that if a case is appealed and sent back down to courts for additional work, it goes back to that judge. So
Right.
Judge McAfee, as soon as this case was assigned, which it was randomly assigned, we have a random assignment process to prevent political manipulation and judge shopping. When it was randomly assigned to him, he realized he was on this case for life. Whether this case takes 2 years, 4 years, 6 years, 8 years, as long as he is a Fulton County Superior Court judge, this case comes back to him. And in fact, if he gets a promotion and goes up to the Court of Appeals or the Georgia Supreme Court, he would basically be prohibited. He would be recused from hearing issues related to this case and its appeals. And same if he was to end up over in the federal system, as many people speculate that Scott McAfee is due to eventually take an Article III job in the federal system.
Listen, Josh, and this is a fair point. One viewer is writing, Del Rosario is writing, no one is asking what would happen now to the taxpayers' money spent on Wade and Willis.
That's a great angle, and there are some very, very angry public watchdogs out there looking into exactly how Fani Willis spends the resources that have been provided to her office. And that ties into what Jim Jordan is doing up in the United States House of Representatives. Jim Jordan has subpoenaed Fani Willis and required her to supply additional explanations involving federal funds that her office receives. Virtually every DA's office in the nation is supplemented with some federal funds to assist with everything from drug kits and rape tests and additional officers and additional investigators. That brings in the specter of federal oversight, and I don't know how Fani Willis is going to respond to that, other than previously she's basically told Jim Jordan to stay out of Georgia business and has even accused him of trying to manipulate and unduly influence a prosecution, which is a crime in itself.
Josh, any other thoughts, any other angles we have not talked about?
I'm waiting for my hair to get longer, thicker, and my abs to show up, which may both happen by the time this case is done. What I really want to talk to people about is the fact that this is a long way from over, and today represents a moving of the goalposts more than anything. I personally believe that Fani Willis has a very small opportunity to regain the calendar speed she wanted from the beginning. I don't believe it's very likely that this case gets tried prior to the November election. And after that November election, shake the dice and roll them again. Who knows what's going to go on? We've never had an elected a leader or someone that may be the president-elect be up on criminal charges. And it also brings up the idea of actually trying to have a criminal trial if he was elected and assumed office, something that I don't believe is possible. I guess theoretically it's possible. We're not prepared for that as a country, I believe. So this is earth-shattering stuff.
Yeah, absolutely, absolutely. And you know what? If the goal here by the defendants was to deflect or misdirect and shift the attention back onto the prosecution instead of themselves, it seems to be working.
It was a very well-executed plan. You could easily say that the goal of the defense since this case was brought was to both push back the trial date while creating a muddy vision or a muddy set of waters for the people to view through. And they've done that. They've taken other issues, conflated them, brought up additional information, and made what was a smaller and discrete complicated case into a massive and even more complicated, huge case. It could literally take years and years to untangle this web.
So I want to talk about also, there is an elephant in the room that we haven't yet touched on, and that's race. And I have one viewer who's writing, it's all about race.
And that is an extraordinarily valid and salient point. I am blessed to know lawyers of all stripes and diversities, and it has been an ocean of complaints of the unfair use of race specifically against Fani Willis. And there are people that have alleged that Fani Willis is being so aggressively targeted, and targeted in the way that she has experienced due to the fact that she's an African American female. And there's legitimacy to some of those attacks because, unfortunately, I've witnessed some really inappropriate, disgusting racial barbs, arrows, whatever you want to call, thrown at Fani Willis. I've also seen some really awful racial language be used and alleged against the defense, basically everyone else involved in this case, because race is an inherent part of political conversations here in America, and you can't get away from those optics. I feel that it's an important discussion to have, but I don't believe that there was a racial motivation involved in the charging or the methods of defense. It's just that race is inextricably linked to the criminal justice system as a whole.
And whoever was prosecuting Mr. Trump, you think that his team would fight against, regardless of their race?
Absolutely. Mr. Trump and the assorted co-defendants were going to hire some of the best lawyers around, and they have. I know these lawyers. I've practiced with them for 20 years. These are the people that I would have hired. They're that good. So we all knew that the fight in defense was as zealous as we dream about here in the justice universe. But we also know Fani Willis. She is a extraordinarily successful, sophisticated, and accomplished criminal litigator by herself. That's not running an office. That's her as an actual trial lawyer. She has a giant brain and understands this stuff on levels upon levels. She is the perfect person to handle a case of this size, magnitude, and complexity. It's just that right now we've seen some of the troubles she brought about on herself through the relationship with Mr. Wade, something that I don't believe anybody really thought about when the relationship was necessarily starting.
Yeah, which is a little bit surprising because, you've got two very intelligent attorneys. You'd think that they would be aware of the repercussions. You'd also think they'd know that the text messages and the phone calls would be accessible down the line. And
historically, if there's the old saying about, do not represent yourself, a fool for a client. She should have, in retrospect, certainly gotten some independent opinions as to her choices, and I think she would have made them very differently.
Well, yeah, that's fair. Any final thoughts, Josh?
Just thank you so much. I encourage everybody, watch this. Talk about it with your families. I know politics and the law can be kind of dry. This is anything but dry, and it's incredibly important because this is history unfolding. They are going to be reading about this in books in 100 years. This is as real as it gets.
Yeah, absolutely. Thank you so much, criminal defense attorney Josh Schiffer, joining us here on Atlanta News First Plus. And I just want to encourage everyone, because we're going to continue to follow more developments here. As Josh has said, we can expect appeals. There are applications for appeals. So there's a lot that's going to happen down the line, potentially even a resignation by Mr. Wade. So there's a lot that we're watching. If you haven't done so yet, please download our free Atlanta News First mobile news app. You can get updates sent right to your phone. Thanks so much for being with us, everyone.